Welcome to Case by Case. This is a podcast brought to you by Calum Chain and Luke Zadkovich from ZFZ. I'm Luke. Calum, how are you?
Yeah, I'm good. I am, like all parents of a 2-month-old baby, more tired than I would normally be, but maybe more joyous as well.
Yeah, in that early phase, I don't know. I kind of found the jump from 1 to 2 a bigger step than 0 to 1. I don't know. Maybe it's a bit early still for you, but I found it quite a juggle.
It's one of those things where once you've done something once, the second time is always easier. I suppose it's the same with when we did this podcast. The second episode's easier than the first, but you look back and wonder how you managed to make such heavy weather of one. And then you have a second one that comes in, and it's suddenly all of the stuff that you thought was so tricky with one becomes even trickier with two. And you just think, how, if only we had the time that you had with only one child. And then, I remember going back to when we had our first and thinking, we have no time at all. This is impossible. I think it's the nature of parenting. And there'll be people who have 3 who will say two is easy. That's just the way of parenting. You'll always feel like you're on the back foot. And that's the state right now, 2 months in.
Yeah, I totally get what you're saying. And actually thinking back, I don't know if I've mentioned this to you recently, but our second was born 2 months before we set up the law firm. So, going back 6.5, almost 7 years now. And the young guy was had just arrived, and so we've been planning and preparing, what have you, before he turned up, and then we kind of just jumped straight into it, Ed and I. It's amazing to think how much has changed since then.
That I don't envy you. That is hardcore to be going for 2 children, 1 new law firm, and here we are, 6 years on, 6 and a bit years on.
And I think it was described as brave, bold, some other synonyms of that.
Those are the polite ones.
Yeah, exactly. Which is code speak for crazy. Anyway, it's been a little while since we've been on the podcast. We took a 2-month break for paternity leave, and I've had some annual leave and been traveling. I've actually been on the road the last 2 weeks. I was out in Singapore and the west coast of the US, went to the Maritime Law Association Golf Day in San Francisco. So it's good to be back in the office, doing podcasts, doing work, not in that order. Today's case, I think, is a good one to ease back into it, hey?
We didn't want to bite off too much more than we could chew with the first one, and our technical mishaps on the way through to launching this podcast, or we're getting this podcasting session off the ground have probably been testament to what a sensible decision that was. So we've gone for an interesting London Arbitration Award. They're typically a slightly shorter read, but there's a lot of detail in this one, and a lot of interesting issues for, in particular, our shipping clients out there, our shipping listeners.
Absolutely. I think this is a great one. For shipping contacts, it's right down their alley. And also, I think it involves a geographical area that's always a hot topic in the Mississippi there. And we had Hurricane Ida come through. This was back in August 2021. Yeah, August 2021.
Late August 2021.
A significant hurricane, perhaps not the biggest, and outside the norm. And indeed, that was one of the comments made by the experts, that it was well in season and but significant nonetheless. And got a vessel here that was at an anchorage in the river, so not out at Southwest Pass, but actually in the river, and suffered some issues as the hurricane came through. And it's a neat, if I can describe it like that, factual background for us to look at, some additional tug costs that were incurred. There's a hire claim, and there's also an interesting hull fouling claim thrown in there, which you wouldn't normally think jumps out at you as for this type of factual issue, but that's in there for good measure as well.
We see a few with the Mississippi. Obviously, here we had Hurricane Ida, but the Mississippi is, as you'll know, particularly over on the US side with the US work, it's a difficult river to navigate, and we see a lot of issues in the Mississippi around the anchorages. This is this is a fairly typical fact pattern for that part of the world.
Yeah, exactly. And should we just give some of the short facts on this, Calum? I think that might be a good place to start.
This is a claim that was brought. I can't remember whether it was technically brought by owners or charterers. It was one of those claims that you see all the time in the world of charter party disputes, where there's a balance of accounts dispute. Basically, the charter party has concluded, the parties have each paid what they think they owe, and the balance is not zero. One party says they're owed a little bit more, the other party says we've paid everything that we owe you, or indeed both parties say that they are owed a little bit either side of the line.
I think charterers may have deducted, and so technically it could be an owner's claim, but it doesn't really matter.
It's one of those claims that you see where the claim by owners is a claim for payment of hire, very straightforward. You owe us this amount of money for hire, or indeed here for additional things like tug assistance or hull cleaning and hull inspections. And charterers say no, we're fully paid up. We're finished with this charter party. And then as you go through the pleadings, obviously those are all fleshed out. Interestingly, this was on the LMAA intermediate claims procedure. That's not one that I come across very often, to be honest with you. We see a few on the LMAA small claims track, and we see obviously the majority of the work that we do tends to be on the LMAA kind of full bore procedures, if you like. The intermediate claims procedure is one that I've seen less often. But it's there, and it's there to be used by maritime practitioners. A kind of efficient, it's intended to be an efficient way to resolve disputes that are larger than the kind of small claims threshold that you see, but maybe don't require the fullness of LMAA procedure.
Yeah, and indeed, this one was decided on a documents only basis, including with expert reports from both sides and a joint memorandum produced by the experts. So there's still quite a bit of evidence went into this that had to be prepared, but then the arbitrators decided on a documents-only basis. And an interesting point on that is, and this is, I think it's become increasingly more common. So I don't know if the LMAA arbitrators have got their heads together and said, look, where we can agree without appointing a third, let's do it. Because I've seen this happen a few times, actually, where you have an arbitrator appointed by each of the parties, and they don't go ahead and appoint a third, like a chair, if you like, and instead just the two of them agree on the position and issue an award by the two of the three arbitrators, which is completely allowed, no issues with that at all. But it is an interesting dynamic to note.
As particular case, obviously, if it's documents only, they don't need to bring in the third arbitrator for the hearing. Just in case, they can go ahead and make their determinations. They both agree with each other. They proceed to write the award, and a lot of the cost of litigation or arbitration is removed if it's documents only. I think that as practitioners, you're always going to have that kernel of doubt in your mind as to whether a documents only determination or documents only decision is whether the tribunal have had the opportunity to look the whites of the eyes of everybody, all the experts, really test the points with the barristers that they want to test. But the flip side to that is that a lot of these disputes are not huge value, and the cost of a hearing, even a short hearing, is expensive. When by the time you've roped in the experts for the day and you've got the tribunal together for the day, you've paid for the room fees. It really does add up. So we see a lot of determination on the papers, and you just in the lawyer's shoes, you just have to make sure that really all of your points are completely bottomed out, because the papers are the papers are the papers in that situation.
Yeah, look, I've had a bit of a mixed bag on documents only decisions. I do have a preference for a hearing where possible and where it's appropriate. It just because I think it also gives the arbitrators an opportunity to ask questions that are on their mind. And I found, as an advocate, that when the fact finder has the opportunity to ask some questions, you can not only provide answers, but you can kind of see where they're going, what's troubling them, like where is the real issue for them in the case, and whether you deal with it through the oral advocacy or you clean it up in final submissions, written submissions. I don't know. I think it can be a better way of getting to a more informed decision, but that's got to be weighed against the costs of doing so, and the nature of the issues in dispute, and there's a number of other factors as well. And this is one of those ones where I think, the Charter has put forward some good arguments here, but ultimately, and I'm, spoiler alert, but ultimately I think they were up against it, and weighing your own merits into these kind of tactical decisions comes into it a bit. With all that said,
yeah, we could talk about the pros and cons of this for a long time, and we do indeed with when advising clients. But moving on to the facts here, in very brief, the vessel arrived on the 18th of August, tendered NOR at the Alliance anchorage in Mississippi on the 19th of August. The weather as of the 21st of August was calm and sunny. But that was not to last. By the 26th of August, there was a storm predicted, and 48 hours later, the storm was very much hot on the heels of the vessel. The master at that point, this is the 28th of August now, in the morning, the master recommended going straight into a load berth or getting tugs or leaving the anchorage entirely. There was no response to that, and as a result of the weather coming in, the vessel grounded. Ran aground at some point in between 28th and the 30th of August. And the master called for tugs to kind of re-anchor the vessel, bring it back into position. There was, then the storm moved on. But again, on the 12th of September, there was a second issue where the vessel ended up kind of spinning 360 in the anchorage due to high winds. And again, there were costs incurred as a result of that. And the final issue was a claim for hull cleaning. There was a build-up of marine growth on the vessel. The owners relied on the long port stay clause. I said we've been here for over 25 days. A lot of our listeners will be familiar with this. I suppose starting from the top, if you leave a ship in tropical waters for a significant period, a few weeks, it will start to grow barnacles and other marine growth on the bottom of it. That slows the ship down. Slowing the ship down means things take more time and use more fuel, which is very expensive. So the parties apportion the risk of that type of marine growth, often by a long port stay clause. There was one in this charter party, which will be familiar to a lot of people involved in shipping, which said if the vessel stays in tropical waters or stays at port for 25 days, the hull cleaning is for charterers, on the basis that it would have been charterers' orders that led the vessel to stay there. That was resisted by charterers here on the grounds that it was a freshwater anchorage, and therefore the marine growth that was found on the ship could not have happened during the long port stay.
So there are three claims, right? And just on quantum, to give listeners a bit of a feel for how much was in dispute here. For the first of those claims, owners were claiming 17,000 odd, being the cost of the tug assistance on the 31st of August to refloat, shift and re-anchor the vessel. So that was the first of the claims, and we're going to talk about each of these separately. The second of the claims was for about 145,000 in total, which related to the tug assistance to disentangle the anchor cables and related hire and lost time during the tug operation. So that was the second of the claims, and then the third one is the one that Calum was just mentioning. Then the $32,000 claim for inspection and cleaning of the hull, that was much later on the 28th of November in Singapore. So the first of these is about the issue on the 31st of August, and really the claim here was put on a number of different bases by the owners. So this is for the tug assistance. They allege that charterers were liable for that on 4 different bases, alternative bases. One is that the anchorage was unsafe, so bring in an unsafe port claim. The second basis was that the typical clause 2 of the NYPE form here existed, and that the charterers were responsible for port charges, recommended pilotage, and other usual expenses, including tug costs. And the third basis for this claim was implied indemnity under Clause 8, and that's the indemnity for following the charter's orders as to employment. And the fourth was that charters were in breach of their warranty that the vessel would always be afloat. And, in circumstances where you've got so many bases to claim this and no clear kind of owner's fault in this situation, I think owners were in a good place heading into this debate.
Yeah, and it was interesting. I find these types of claims quite interesting when it's clear that owners are basically saying we need, this is not our fault. We've done everything we're supposed to do. You tented this port. You need to pay us for the costs that we had to incur to be there. But there's not really a clause in the charter party that says where this isn't really owner's fault. It should be for charterers to pay. So they had to try and find, which clause of the charter does this actually fall under. Some of those failed. The port was found to be safe. It wasn't an unsafe port per the tests in the Eastern City and the Ocean Victory. But equally, some succeeded. It was found that the vessel was not always afloat, and that's what the charterer's warranty requires. That they'll use the ship in a way that ensures that it is always afloat. So it's interesting to see almost on they had the dartboard of different options, and it's funny to see where the darts landed and where they missed.
Yeah, exactly. Where there's no clear evidence that the master did something wrong. I think when you have that other language there and a vessel does run aground, there was some debate about whether there was enough of a showing of grounding, but really the evidence was pretty convincing on that. Was my read of this summary. Once you have a vessel grounding without clear master negligence, and okay, we've got the interplay of cogs are in there as well as a defence, but even putting that to one side, it's going to be difficult to get around the express warranty as to the vessel remaining afloat.
Agreed. That was always where I thought there, as you say, as soon as the evidence goes against you there, you're in trouble.
Yeah, but it also succeeded on the other counts as well, because the tug's assistance was necessary to enable the charterers to comply with their warranty that the vessel would always be afloat. So that's the clause 2 point. And also under the implied indemnity under clause 8, the owners got in on that basis as well. So the first claim for $17,000 relating to the 31st of August, the cost of the tug assistance, that succeeded without too much fuss by the looks of it.
And then we move on to the one which I thought was the most interesting interplay between the clauses and the facts that were found. And this was the tug assistance on the 22nd of September. And this was where the ship had lines tangled, and it had been caught obviously in some kind of current with high winds as well, and seemingly it had done a 360-degree swing. The question was, well, the first question is, and I imagine the question that charterers spent a lot of time focusing on is, how did that happen? What was that caused by? Was that caused by the master and his negligent seamanship, or was there no kind of ordinary good seamanship that could be done to prevent it? That's an interesting question, but ultimately it wasn't determinative here.
And what was interesting about this point is, correct me if I'm wrong, Calum, but it's not really related to the hurricane. This is a good few days after the hurricane had passed through, and the vessel had moved into a different, or shifted to a different part of the anchorage where it had been waiting. They had gone a little deeper and at an angle to the berth. But so in that way, it may have been positioned post-hurricane, but still that wasn't, it's not really related to the hurricane. It more pulls in other factors about how the master handled this issue.
Exactly. The hurricane has, by this point, been and gone, and we're looking at a totally different set of facts, well, related but different set of facts. There
was this risk in the way that the vessel was kind of positioned in the channel, that with the flow of the river and with the wind, there was this risk of the vessel swinging 360 degrees, and the master could either look to move the vessel and correct it from that position, or take this risk that the vessel could swing at 360 degrees. And the master made the decision to take that risk that the vessel could, and that would be the more prudent course to take. There wasn't sufficient evidence that the master assessed the risk and considered kind of possible preventable action that could be taken. And also, it seemed that the master hadn't done much for a good week or so. So when the berth was actually free and the vessel was able to go in and then had to undertake this manoeuvre, that kind of lack of planning led to some of the delays that we're looking at here. So there was, in this case, unlike the last issue, which related to when the hurricane came through, this one did have some kind of negligence, if you like, in how the master decided to deal with the issue from a planning perspective.
The tribunal found that the master's actions were serious and negligent, or they constituted a serious and negligent omission. So the tribunal wasn't afraid to find that there was some wrongful conduct on the part of the master. The interesting question then is, what's the effect of that on the claim? And is that in itself enough for charterers to win, and for owners to have to bear the costs of the tugs and to bear the off hire of the time that they spent waiting for the berth, or are there other things going on? Kind of preempting the answer here, but were there other things going on that meant that this was still on hire and the tugs were still charterers' costs?
There was also the point made here that this second anchorage position, so where the vessel was before the 360 spin, that it was not safe for the vessel, but the additional costs were not really incurred because of that unsafety. It was rather the master's negligence in failing to act promptly to remedy the situation that was the issue. But you've got the clause paramount to contend with, right?
The clause paramount, obviously incorporating the Hague-Wisby rules, gives the owners a defence to claims brought in circumstances where the master has taken almost exactly this type of action under Article 4, Rule 2A. The
master's conduct did fall within that defence, and the owners were able to succeed on this claim, and that the charterer's deduction was wrongful. So they get through. And look, my point on this, Calum, and it's a question, going beyond this case and thinking about it more broadly, is, do you think there's a debate to be had about whether incorporating the cogs of defences into charter parties is appropriate in all cases? And I raise it because, obviously we've dealt with this a lot, and there's such a body of law that is built up now on that proposition and on that understanding. But I do wonder sometimes whether the defences that were agreed with respect to cargo liability regimes are actually appropriate when looking at the allocation between owners and charterers for these types of issues. I don't know. I think there'd be an interesting thesis to write around whether parties do consider that the blanket incorporation of cogs of defences into charter parties, so into charter party claims. I'm not talking about cargo claims, all right? That's an appropriate place for them. They've gone through the debates. They're on the basis of international conventions that have been around for almost 100 years now or more. So that domain I understand, but the blanket incorporation of them to apply to charter parties, I think there's a paper in that. I really do.
I'm with you. You see it a lot. You don't see it. It's not ubiquitous, but you do see very frequently in the clause paramount the wording that extends the clause paramount into the charter. So it's not simply saying all bills must include this wording. It says all bills must include this wording, and then words to the effect of, and it's also incorporated into this charter. And it does bring in a regime which is slightly at odds with some of the other provisions of a charter party. Hence the fact it's the clause paramount. It's paramount important, etc. But it is interesting in some circumstances whether or not it makes a great deal of sense for an owner under a charter party regime to benefit from these protections.
This might be the type of example. Does it feel like it properly rests on charterers here when the master was negligent and didn't properly plan for this issue? I'm not so sure. Anyway, look, I just pose it for debate. I don't know. I just think there's something to be had around, like, if you sat the parties down and really talk this point through, in a theoretical way, and said, look, these are the situations here. Who do you think should be responsible for this? And you use examples with COGS defences for owners, being incorporated and without. I'm not sure you get the same kind of answers as you would in a cargo claim scenario.
Even if the COGS defences are incorporated, and there may be a case exactly on this point, and I'm just ignorant to it, but would that necessarily cover you for as a defence to an off-hire claim? If you say we have all of the defences available to us under COGSA, which means that we have no responsibility for loss or damage resulting from negligence of the master, say, in summary, does that necessarily mean that you're not? It's almost the way that the COGS defences, the Hague-Visby defences are written, isn't on all fours with an off-hire claim. It's talking about something else. It's talking about damage to cargo or some kind of claim for loss or damage. Whereas an off-hire claim is it's a contractual remedy saying we're not liable to pay you money during this period. And maybe there is a case exactly on this point. Maybe our listeners will excuse me for not finding it if that is the case in the circumstances with the 2-month-old child, as discussed at the top of the podcast. But I do think that's an interesting. I think it's an interesting question, and I'm sure that the arbitrators looked in a lot of detail at it when making this award. Obviously, we don't see the detail of the award in these London arbitration reports. But that did jump out to me as a slightly interesting question. Does off-hire naturally fit within a Hague-Visby defence? Yeah,
I think there's something to that because they are different regimes. I can see how the COGSA regime can be applied, stretched and pulled and whatever else, to apply to damages claims under a charter party, with the usual common law principles that apply to damages claims. And yes, you can introduce the cargo regime into that. It's not as clear to me that those defences, which sit kind of nicely within a damages context, apply to a contractual delay allocation clause like an off-hire clause. So I totally see what you're saying. Look, interesting points. Maybe we're identifying a couple of papers to write at another time. But should we jump onto the whole cleaning claim?
It was interesting reading that effectively the defence here from charterers was it's not possible that the marine growth that affected the ship during this period was caused by this long port stay, because this long port stay was in fresh water rather than brackish water, and therefore there would be no marine growth. And the experts seem to agree, or at least the kind of common view of the experts was it leaning in favour of the fact that if this had been fresh water, then there would have been no hull fouling during the stay in Mississippi. And then there was this piece of evidence that was adduced that said, well, actually, due to particular weather conditions, I think it was a drought, there'd been an inflow of tidal water as far as 64 miles upriver. And because the events kind of played out between 63.6 and 65.8 miles upriver, the owners relied on this news report to say, look, actually, this shows that there was salt water present, and because there was salt water present, we should get paid our hull inspection and hull cleaning costs.
I was just looking at the language here of the clause. And the language of the clause is, and I won't read it all out, but the bit that got me interested is where the vessel remains at anchorage, in port or idle for a period exceeding 25 consecutive days, whether in tropical waters or not, right? So it could be any type of waters, in compliance with charterer's orders instructions, and this causes fouling of the hull or underwater parts, owner shall not be responsible, blah, blah, blah. It's that language, and this causes fouling. I'm going off recollection, but I was trying to look quickly at the BIMCO clause as we were going through it. Is the causation test usually that pronounced in an underwater hull cleaning clause? Because I thought if you get the 25 days, there's almost like a presumption of fouling, and owners then get the benefit of charterers having to pay for the cleaning costs, and they don't really have to do much by way of proving that the 25 days led to, like those 25 days led to the fouling of the hull.
I've not seen the argument in this way before, and I couldn't remember whether that's due to the way the clause is drafted, or whether it's just the peculiarity of this being a freshwater berth or freshwater anchorage, and the dispute being around this causation point. I'm not sure whether the issue never comes up, and it's always obvious that there's this causal link, or whether this wording is new. But I think the wording is new. I think normally you just have it is
new. I think it's new, Calum. I could be wrong, but to me, this places a causation element into the underwater hull cleaning clause that I must admit I'm not sure I've recalled that argument before in other clauses. I thought it was more almost a presumption, or is it that you do the 25 days in tropical waters. You could argue that by having the language whether in tropical waters or not, that then justifies having the causation element to it. But at least my recollection is, if in these types of instances where it's 25 or 30 days, if you clock that up in tropical waters, then owners can say to charterers, you've got to clean the hull, basically.
Exactly. That's exactly my recollection of it.
Yeah, I know. It's funny. I should know this, off the top of my head, and I hadn't gone back and looked at other clauses. I know we've dealt with many of these before, but so just while you're looking at that, the other point on this for our listeners is an evidential one to just touch on. The owners were behind the eight ball on this, or behind where they should have been, because they didn't really lead any expert evidence on this issue. Charterers did, and I think realising that they had problems on this claim, they tried to slip in with their closing submissions a news article that talked about the water in the Mississippi not being just fresh, and that some of the salt water had gone up to 64 miles upriver, and the arbitrators, would not have been impressed by that, number one. I think it's probably fair to say, but then allowed it in, admitted it, and then gave it very little weight. And they went on to say that the news article, wasn't clear about what 64 miles meant. It did not specify what year or month the information applied to. And there was no evidence in the article of the degree of salinity necessary to support the relevant marine organisms that owners had alleged developed. So just trying to get the news article in, as a last-ditch Hail Mary kind of play, didn't work, because the evidence that was adduced wasn't really tailored, and it didn't apply to the real issues in dispute. And I think it's another one of those practitioners' points which we sometimes talk about, that you've got to really contend with all the issues in dispute. You've got to consider whether you need expert evidence to make them out, have the other side put in expert evidence, because this is how things can play out. And
I've just gone back through a few that I've been working on in the last year or so, as well as the BIMCO clause. And this causative element is unusual. The whole clause is slightly unusual, but this causative element is a kind of standout, unusual piece of wording. So I suppose well done to charterers for getting that in the negotiations, because it saved them $30,500 ultimately, because owner's claim failed because they couldn't show that causative link and the evidence wasn't strong enough.
Exactly. It's funny. I was going off recollection, but it's good to know that the memory works sometimes.
I had to say, I was reading this, as I was reading it, I just thought, why are they arguing about, all of this factual causative stuff? And then I had to go back and read the clause, and I thought, oh, that's unusual, I think. The instinct was right.
Good, Calum. Well, I enjoyed that. It's good to get back on the horse and be riding again in the podcast world.
It's good to be back. It is good to be back. It's a bit rough around the edges, I think, for our first one back, but I'm sure we'll be back in the groove by next week.
We will too. We've managed to stretch out an LMLN podcast out to what, 45 odd minutes. So we'll tighten them up as we go. Thanks for sticking with us. If you've gotten this far along, thanks for sticking with us. We hope you've enjoyed it. I really do genuinely enjoy reading these cases and staying up to date with everything and catching up with you, Calum, as always. So thanks for listening. We've got more coming to you. We don't just do shipping cases. We do all sorts of other cases. And we've got some good ones stacked up, ready to come your way. So thanks for listening. Please do subscribe, follow, like, share, all those great things that podcasters like you to do. It's very much appreciated. And here's to this next series.
Cheers, Luke. And thank you also to all our listeners. Good to be back.